So thank you all for coming here to my Clemency Clinic's presentation on our recent trip to the UK. This was our third trip in the last couple of years to study more humane incarceration and sentencing regimes. So the UK has a fairly high incarceration rate for Europe, 134 people per 100,000, but it's still significantly lower than the incarceration rate in the United States, which is 541 people per 100,000. It has been experiencing what it has described as a prison crisis lately, meaning that they are running out of prison beds. As a result, you'll learn they've been lowering the amount of time that prisoners have to stay and serve of their sentences in order to release prison beds. And there's an interesting conversation happening there about building more prisons versus decarceration efforts. So it was a really interesting time to be there. I want to especially thank all the people who made this trip possible and gave us excellent advice about planning it, including making introductions for us. Jan Bauer, the British Consul General Representative here in Minnesota, Professor Julian Roberts at Oxford University, Philip Bowen at Justice Innovation, Magistrates Amanda Gibbon and Bench Chair Gwilyn Wright at the Highbury Magistrates Court, Judge Sarah Monroe at the Old Bailey, the staff at St. Giles Trust, Pentonville Prison and Grendon Prison, and the lawyers at the Irish Lawyers Association in London, especially Kerry McGuigan and Will Green at Peters and Peters Solicitors and Thomas McGarvey at 2BR Barristers. And of course, I just want to thank my wonderful students who made it such a terrific and memorable trip for me that week. And now I'm going to turn it over to Ryan Clemens, who will begin the presentation. Thank you.
Two together seems to be. I'll just use this one. That works well. Okay, hi everyone. Thank you so much for coming. This is a bit of an overview of what we're going to cover today. So we'll talk a bit about the criminal courts that we observed, both Magistrates Court, which you'll learn about what that is, and the Old Bailey. We'll talk a bit about the prison crisis in the UK and also sort of how it impacts how we think about our own crisis that we're having here in terms of mass incarceration generally in the United States and sentencing. And then we'll also talk about various rehabilitative efforts that we observed. And we like to think about how that can impact our own advocacy in the clinic here. And a really, really interesting therapeutic prison approach. We visited the only therapeutic prison in Europe. This is just an overview of the system generally. You can see that there is a UK Supreme Court like our court, but really we focused on the Magistrates Court and the Crown Court. So that's what we'll be talking about today. Those are the courts that we visited ourselves. We visited the Highbury Magistrates Court, and if you've never heard of Magistrates Court, like I had no idea what that was before we went there. All criminal cases start in Magistrates Court, and 95% of cases will be resolved in Magistrates Court. And Magistrates Court is overseen by lay magistrates. So these are people who are not trained lawyers. They have legal training, but they have legal training in that it is on-the-job training, but they're not lawyers in the way that in our system you have to become a judge, you have to have been a lawyer first. They're entirely voluntary, so they're unpaid, and they must work at least 26 and a half days per year to maintain their position as magistrates. And what that means is that a lot of folks do it in addition to their day job. So they have to have a job that allows them the flexibility to take that time off. And what we learned is that a lot of folks do it upon retirement. The qualifications are you have to be between the age of 18 to 75. you can't have your own criminal history, and you cannot have been a police officer or currently be a police officer. But other than that, it's a pretty general job application process, and sort of the theory behind it is that it is the community judging members of its community. But I think sort of our impression of it, because of these qualifications, that it is entirely unpaid and you have to take time off from your normal job to do it, it leads to magistrates that are typically older, retired, and often in a financially stable position to do this sort of volunteer work. There are over 12,000 in England and Wales, and you can think about how cheap it is for the government to run 95% of the criminal cases with a court that is entirely voluntary judges. And there are district judges, which are appointed in typically areas that have a more robust docket, and these folks are trained lawyers that oversee the cases just like magistrates do. But the majority of people in a magistrate's court are these lay magistrates, and from our impression, it seems, and the little bit of reading that we've done and research on the topic, it seems that district judges and magistrates, it's sort of random which one you will encounter if you are a defendant going through the system. So here is a look inside the courtroom. This is how the courtroom is set up. You can see typically magistrates sit in panels of 2 to 3, and there will be one who is the one who's in charge, and they each have equal input into the decision, but the idea is that one is sort of speaking for the court. Right in front of them, the clerk. This was very interesting for us to learn. The clerk is someone who is a trained barrister or solicitor, and their job is to essentially oversee the law and make sure that the magistrates in their decisions are abiding by the law. But they are not a judge, they are simply an advisor. And so you can think about how the input of the clerk might depend really on the personality of the clerk and how often and how comfortable they feel speaking up when they see that a law is being not fully abided by. There are prosecution and defense attorneys in the courtroom, and often people from probation will sit into the room. It's open to the public. We observed Magistrates Courtroom ourselves. And then another thing that really struck us about this system is that the defendant sits in what's called a dock. Lost my clicker, you can see it to the right. It's a plexiglass, essentially, the defendant sits behind plexiglass, and they are entirely separated from their attorney, which stands in stark contrast to our system here, where you can sit right next to your attorney as a person who is accused of a crime. And what that often means is that to communicate with their attorney during the proceeding, the defendant has to slip them a note or just try to talk to them during the break. And I think the optics of this, just that the defendant is behind a glass, it was pretty startling. So here is a sort of really high-level overview of what a procedure in a magistrate's court will look like. So the charge comes from CPS, or the Crown Prosecution Service. And then once that defendant is brought into the courtroom, the plea will be taken by the clerk. So that happens pretty similarly to how we would see it in a courtroom, where in our system, the judge would be explaining, this is what you're charged with. These are the potential consequences. Have you been informed of your rights? All of those things. The clerk is in charge of making the person totally aware of that. Where it says plea should actually say choice of courtroom. So at this point, after the defendant has been given their plea and taken a plea, either pleaded guilty or pleaded not guilty, then is the point where it is decided if the case will be heard in the Crown Court or the Magistrates Court. The Crown Court you'll hear about in just a little bit, but essentially Magistrates Courts only have the power to sentence up to 1 year. So the idea is that a different type of crime is heard in the Magistrates Court than in the Crown Court. So cases that Again, they still always start in the Crown Court, or sorry, in the Magistrates Court, but cases that will sort of automatically be pushed into the Crown Court will be murder, manslaughter, rape, robbery, these offenses that carry a sentence of more than a year. And then you have crimes that will certainly be heard in the Magistrates Court, so smaller assaults, drunk driving, drug possession, indecent exposure, those types of cases. And then you have what's called either way offenses. So in a situation where a defendant is charged with domestic violence, sexual assault, theft, drug offenses, or certain weapon offenses, the defendant has the choice whether they want to be heard in the Crown Court or Magistrates Court. So the defendant can assert their right to be heard in the Crown Court, or they, in some instances, the magistrates might say, we think that this should go to the Crown Court. We just think that it's too serious of an offense. But that's a choice that the defendant is often given, maybe with not being totally familiar with how these two segmented processes work. And it's after they take the plea, so that's interesting too. So essentially, if the defendant has pleaded guilty, then the magistrates will be the one that sentence right then and there. And there might be an adjournment, but typically it happens pretty fast. And then the defendant's solicitor can offer some mitigation evidence for a reduction in the severity of the sentence, maybe a pre-sentence report, or like what we think of as a pre-sentence report, where the probation service puts together a history of this person's life and tries to sort of explain the events of the offense, will be put together, maybe not. It's not quite clear exactly when that happens. And then the defendant will be sentenced according to guidelines that you'll also hear a little bit about. If the defendant has pled not guilty, the Magistrates Court has the decision to remand the defendant essentially back into custody, or to put them out on bail with certain conditions, and the magistrates will be the ones who decide about those conditions. A trial date is set, and then the magistrate or the district judge will preside over that trial. And the Magistrates Court is supposed to be efficient. It's supposed to be fast. I read that the trials can often resolve themselves the trials are expected to last between 1 and 4 hours. So it's not necessarily our system where trial could last multiple days. That's an overview of Magistrates Court.
So I'm Tiffany, and I'm going to be talking about our time. On our first official day there, we got to see and the Old Bailey is a central, and it can be traced back to medieval times, back to the 1500s, and it experienced a lot of reconstruction and expansion. And the history of the building is evident in artwork, and even a glass shard being there from an IRA bombing in 1973. They explained that there's the shard still in the wall, and we saw it, and it still serves as a reminder to the court of what happened. The artwork up there, it's truly beautiful, and we got to walk around and see all of that. And today, the Crown Court currently sits in the Old Bailey and hears major criminal cases within Greater London. During our visit, we got to see part of a criminal trial, and there were a lot of similarities in the U.S. trial of how attorneys advocate for their client, and we saw a witness take a stand, and the Crown and defense both questioned him. However, during the trial, we saw how judges and attorneys and barristers really do wear wigs during the whole proceeding, and it was really to show respect to their legal history and portray a formality, which is very different from what we see here. To go more into the differences besides the appearance of wigs and attire, one key difference we noted was how judges marshal the evidence. In our courts, judges just explain to the jury what the law is and give questions. But judges in the UK go a little further and recap the evidence and kind of summarize the case to you. Additionally, during the trial, we saw a book of evidence that was prepared and given to the jury members. And this included images of injuries, the defendant, and all other relevant evidence used. The members of the jury had this booklet from the start to finish of the proceeding, and they could reference it at any time. In the U.S., evidence is only presented by the attorney. It can be used during jury deliberations upon request, but it's not given to juries to look at. Another significant difference we noted were differences between defendant and defense barrister dynamics. Brian talked about it a little bit, and in the U.S., we see defendants sitting right next to their lawyer and having that instant communication and access to their lawyer. However, in the UK, in the Crown Court as well, there was a glass enclosure, similar to the ones we've seen in Magistrates. The defendant communicated via notes during the trial using clerks, but it was very separate from the attorney. Finally, there is no transcripts of the case during the UK trial. Instead, proceedings are recorded. The record is ever needed. US transcripts are an important part of our system, especially with the appeals process. Finally, I'm going to go more into the differences. While the US has a general term of attorney or lawyer in the legal field, the legal profession in England is split into barristers and solicitors. Barristers specialize in courtroom advocacy. They're required to wear the wigs that we saw. And their primary role involves representing clients or the Crown and advocating on behalf of the court. This includes responsibilities of interviewing witnesses, preparing case details, and just presenting. And barristers are often self-employed and work in chambers. In the US, this is kind of similar to the work of prosecutors or defense lawyers, but in the UK, a barrister can go from representing the Crown one day in one case and the defendant in the next case. So it just switches their roles. Solicitors handle most other legal work and provide specialist legal advice to their clients. They don't have to appear before the Crown or wear wigs. Their legal work includes handling client matters, drafting documents, advising on legal issues, and managing case details. While their work primarily revolves around clients and other legal issues and handling that, they frequently interact with clients on a one-on-one basis and have a capacitated version of representation. There is an intersection between barristers and solicitors. Barristers often use the legal work carried out by a solicitor to prepare ahead of trial or for hearings. Generally, a good way to think about it of the difference is that barristers are specialists in advocacy in representing clients in higher courts.
Hello, everyone. My name is Emily Westover, and today I'm going to be talking about the difference in sentencing. So, just as we have sentencing guidelines in Minnesota and in the federal system, there are also sentencing guidelines in the UK system. However, they operate slightly differently. There are very strict step-by-step guidelines for every single offense. They're written like a recipe. Step 1, you look at this. Step 2, you look at that. And courts must follow them. So this is an example of the starting point for sentencing. So this is for the charge of bribery, which is I've picked because it is a charge that could go to the Crown Court or the Magistrates Court, because depending on the seriousness. So this could range from a fine to a community order, which is the UK equivalent of kind of what we would call like a probation or parole requirements that the person has to abide by. So something like prohibiting interacting with certain people, prohibiting going to certain areas or contacting victims, having a requirement of doing some sort of rehabilitative work or drug treatment, and certain number of hours of unpaid work or community service. So that's what a community order is. And then it is also a sentence that could end up with what they call a custodial sentence, which is a sentence where you serve time in prison. And so you see here the first thing that is done in the sentencing guidelines is determine the level of harm and the level of culpability of the person. And they go from category 1 to 4 of harm, so 1 being the most serious and 4 being the least serious, and then culpability, so how big was your role in the offense. So for bribery, for example, someone might be in a category A if they were the major participant in some sort of bribery conspiracy. They were exerting influence over someone else, whereas someone might be in the level C of culpability if they were someone who was sort of forced into this scheme by the influence of someone else. So the first thing that a magistrate or a Crown Court judge must do is figure out where they fall in the category for that particular offense, and that's where they start at the starting point, and then they will determine where in the category range something falls. So then they would consider aggravating and mitigating circumstances, just like a sentence in the U.S. And then if they had helped the prosecution, they may get some sort of reduction. And if they took an early guilty plea, then they could also get some sort of reduction. They also must consider if someone is charged with multiple offenses, they must consider in the totality of the circumstances whether the sentence lengths for all of their offenses combined are proportionate and fair. If someone is charged with 5 different offenses, maybe 50 years in prison is not proportionate to what those offenses actually are. And also, Section 52 of the Sentencing Code also requires that the magistrate or the judge give the reasons for and explain what the effect is supposed to be of each sentence. And this is just a chart that is sort of illustrating the ways that magistrates and judges are supposed to be considering sentencing. So this is considering the purposes of sentencing. So you'll see here, it's always asking, is the offense so serious that it would require a particular type of sentence? So they're always considering what is the minimum sentence that will achieve our goals of public protection and rehabilitation. When we were in the UK, we also visited Oxford University and spoke with Professor Julian Roberts. He's a former member of the Sentencing Council who figures out the sentencing guidelines and sat on that council for 10 years. He's also a former professor here at the law school and also worked at the Rabina Institute. So something he was discussing was sort of the effects of sentencing and what the purposes of sentencing are, and also some of the differences between the UK and US systems. So one big thing is that there are no plea bargains or plea deals in the way that we think of them in the US. So if you take a plea of guilty, you're not getting an offer to deal from the prosecutor of a lesser sentence length or a lesser charge. You may get a max of a 1/3 reduction in your sentence if you take a plea at the earliest first reasonable opportunity. So that leads to there being a very different role of the prosecutor in the UK system. In the US, the prosecutor has a lot of influence because the prosecutor gets to determine, do I want to offer someone a plea deal? What sort of sentence? What offenses am I going to charge? In the UK, it really works. The prosecutor will list the aggravating factors for a particular offense. The defense will list any mitigating factors they have, and then the magistrate or the judge will determine the sentence. The prosecutor doesn't get to say, oh, this is the sentence length that the prosecution recommends. Additionally, there have recently been a lot of focus on the racial and other disparities in sentencing, just like conversations we've had in the US. They've added warnings to the guidelines, at the top of the guidelines, that will point the magistrates and judges to a book about equal treatment, and that has a bunch of different chapters in it about children, young people, vulnerable adults, people with disabilities, racism, religion, sexual orientation, things like that, to help try and reduce those disparities in sentencing. And also, as Ryan mentioned earlier, sometimes pre-sentence reports are required before sentencing, and they have now made it a requirement that if you are sentencing defendants who are from ethnic, cultural, faith minorities, also if very young adults, people who are in sort of domestic violence situations, things like that, that pre-sentence reports are required to get the full scope of the situation and try and make sure that the sentence is actually proportionate to all of the circumstances.
Hi, everyone. My name is Anne Marie, and I'm a 2L in the clinic. And I'm going to talk about sentencing reform and addressing the current prison crisis. As Professor Murray alluded to earlier, almost all of the prisons in the UK are at full capacity. As this chart shows, there are still some spaces left, but even within that, prisons are really at overcrowded accommodations to begin with. And we'll talk a bit more later about the different prisons we went to. But major causes of prison overcrowding include court backlogs from the COVID-19 pandemic, same that we've seen here in the United States, as well as a trend towards longer sentences. In September, the government proposed reducing the amount of time that you have to serve in prison of your sentence down from 50% to 40% for certain qualifying offenses. As part of our trip, we had the opportunity to visit the Center for Justice Innovation and speak with its excellent director, Phil Bowen, pictured above. And the center conducts research into all stages of the criminal justice system, from the circumstances that lead to crime, like poverty and substance abuse, to what happens to people once they're released from prison. And what distinguishes them from maybe other cool think tanks that you are thinking about right now is that they provide hands-on support to practitioners and justice-involved individuals. That includes evidence-based training for police, attorneys, judges, probation officers, social services, and even provide advice to people who have to go into court, like the magistrates courts that Ryan was talking about. So what we were able to talk about with Phil Bowen and the Center for Justice Innovation is on developing criminal legal reform and in building coalitions and allies to actually enact that. The center actually came out of an American organization of the same name, which is based in New York. And so what they've actually been able to do in some parts is to look at US criminal system and think about how certain aspects could be adopted in the UK. So even though we advertise this as what we can learn, it's a two-way street as well. For instance, the US was earlier to the idea of problem-solving courts or specialized courts that tackle social problems like substance addiction, mental health crises, and intimate partner violence. And the Center for Justice Innovation has been involved in spreading those across the UK, even hosting some American judges to come talk about it. Phil Bowen was fond of information and ideas, and he was very gracious to share those with us. Current things that the Center is doing more generally is trying to improve the quality of community supervision or probation, as Emily was talking about, which they believe can be done by improving collaboration between courts and probation officers to divert vulnerable people away from court to begin with, giving probation officers more flexibility in monitoring, and providing more information and choices for victims. In addition, they want to address domestic abuse against children by collaborating between adult mental health care agencies and child protective services. At the time that we visited the center, we had not yet been to either of the two prisons we ended up going to, which you'll hear more about later. So we hadn't seen the prisons crisis for ourselves, but we certainly heard a lot about it from Judge Monroe at the Old Bailey and from the magistrate judges. And it was clear to us just from seeing the magistrate court in operation that there were a lot of bail cases to get through, indicating that many people were in what we would call pretrial detention. There's been some progress, and the Center for Justice Innovation has been part of that coalition calling for change. For instance, they were involved in proposing and advocating for this reduction of time served from 50% to 40%. They proposed that as soon as the new Labor government took office last summer, and it was enacted in a few months. However, 7 months later, the government hasn't been able to do much more than that to reduce prison overcrowding. And just a reduction in time served might not actually be enough to eliminate overcrowding in the long term. Because as Phil explained to us, and as happens in the US as well, the public can feel cheated or tricked when people are released under their sentence. And that can prompt prosecutors and juries to seek longer sentences and offset the reduction. So the Center for Justice Innovation has proposed other actions to both prevent crime in the first place and provide better rehabilitative services after a crime is committed to reduce the amount of people that actually go to prison and spend time there. They propose temporary measures to reduce the Crown Court backlog, such as recruiting retired judges to take on cases and sending some cases back out to district judges that Ryan was talking about earlier. They also want the UK to expand the use of specialist sexual violence and domestic abuse courts across criminal and family justice, since that takes up so much time and resources within the lower courts. To prevent crime, the center proposes diverting people, especially young people, into social skills training, relationship violence prevention, and cognitive behavioral therapy. For repeat offenders, they call for intensive community supervision, not incarceration, and specifically for repeat female offenders who are more likely to experience coercion and domestic violence, for trauma-informed supervision. That is just a sample of the variety of research-based solutions that the Center for Justice Innovation has proposed. You can see more on their website, justiceinnovation.org. And all of these, they emphasize, should be used together to provide opportunities for rehabilitation and treatment before and after any crime is committed. Of course, one of the big roadblocks to any of these reforms is funding. The UK, for really over a decade, has been going through austerity or an overall decline in funding for social services. In the criminal system, this has resulted in a lot of cuts to legal aid and even to prosecution, slowing down the number of cases that you can get through. There isn't enough funding for public mental health or substance abuse treatment that would address some of the root causes of crime. And on the other end, there isn't a lot of funding for alternatives to incarceration, like diversion programs. So it remains to be seen how far that 40% reduction will go and how much other progress can be made. But visiting the Center for Justice Innovation gave us more insight into the future of criminal justice reform in the UK.
Hi, everyone. My name is Caitlin. I'm a 3L in the clinic, and I'm going to be talking about, or starting off the conversation about some rehabilitative efforts that we got to see when we were in the UK. So first, I just want to highlight the amazing work of one of the charities that we were able to visit during our time. We visited St. Giles Trust, which is a UK charity that works to provide life-changing support to people with criminal convictions, and through its work, it's helping people rebuild their lives and reduce reoffending rates in order to create safer communities. So here we are pictured with some of the individuals we met with at St. Giles. So a little bit more on why this work really matters. So in the UK, the cost of reoffending, it costs the UK about 18 billion pounds per year. And so investing in programs like St. Giles does that supports and empowers people who have been in prison, changes the individuals' lives, but also creates safer communities and reduces that financial strain on public services. St. Giles offers a wide variety of support to folks that come in contact with its resources. One of the things that St. Giles is really focused on is reentry services. And so this is assistance with housing, employment, benefits, and other essential services to help ensure that people have a stable foundation when they are released from prison. Another really interesting area of support that we learned about was their youth-specific interventions. St. Giles runs specialized mentoring programs to support at-risk young people, helping them move away from violence and other criminal activities. And they really emphasize education, training, and employment to young people to help them build a better future. They also have specialized women's services. Women in the criminal justice system face unique challenges, including domestic abuse and mental health issues, as well as family separation. And so St. Giles provides tailored support for female offenders, helping them address trauma, access safe housing, and reconnect with their families. Another really important aspect of their work is making sure that people in prison have really meaningful opportunities for job training and work development. Having a job can be one of the most significant factors to prevent reoffending. And so St. Giles actually works within the prisons to run training programs that equip individuals with skills they need to find meaningful employment after prison. And then connected to this piece is one of their really core values, which is harnessing the power of lived experience. And so this means that they work really closely with and employ a lot of people who have themselves been impacted by the criminal justice system in the UK. And so one of the things that they provide is an opportunity to have training to achieve qualification to become caseworkers in prisons. And for some people, they can do this while serving their sentence, and they can start working within the prison as a caseworker while they are still incarcerated. St. Giles also recruits people with lived experiences to work in their offices, and as of the data that they gave us when we visited, about 57% of the paid staff of St. Giles has lived experience. And this aspect really ties back into all of these areas of support. One of the individuals we met with when we were at St. Giles, who works with their youth intervention areas, spoke about her own personal experience in similar circumstances, and it was very evident how well equipped she was to understand and empathize with people going through those similar situations. And then lastly, I just want to highlight the lasting impact and importance of this work. Studies have shown that the interventions that St. Giles has supported has significantly reduced reoffending rates. Participants in St. Giles programs have reoffending rates 40% lower than the national average. So the work that St. Giles is doing is showing that rehabilitation is possible and demonstrates that people can break the cycle of crime through their programs and commitment. Next, I am going to touch on some of the resources that we saw when we were visiting Pentonville Prison. So this is a prison located in North London. It's a men's facility, and as Anne-Marie mentioned, it is basically at its max capacity. When we met with the governor before our tour, I think he said they were 2 beds short of being at their absolute max. And so this is a very common scenario in prisons in the UK right now. But during our tour of Pentonville, we got to see some of the educational opportunities that are available to people who are on the inside. And one of the unique things about the makeup of the prison population in the UK is that, unlike here in the US, where the population of people who are awaiting trial and those who have been convicted are kind of separated into jail and then prison. In the UK, they're all mixed together. So people in Pentonville are both people who have been there and are serving their sentence after being convicted, and then also people who are awaiting trial. And what this means is that in terms of resources, all of those people have the same opportunities to have access to the different educational opportunities and resources, which is kind of a stark contrast, especially in the US for the portion of the population that is awaiting trial. Often jail has a lot fewer educational resources for those individuals. And so it was really cool to see how somebody who's maybe waiting a year or two to go on trial can be working towards a degree or some sort of certification in order to improve their circumstances. So one of the things that we got to see was a business course that is done at Pentonville and is sponsored by local organizations where inmates basically create and pitch business ideas to the instructors, and then the winners actually get money to help start their businesses upon release. And it was just really wonderful and impactful to see how passionate they were about their work and just the sense of purpose that being a part of these programs gave them. And then just on a final note, tying back to St. Giles, the business course that we saw wasn't St. Giles course, but we did learn that Pentonville is one of the prisons that works closely with the resources at St. Giles and often has representatives coming in to work with their prison population.
Hello, everyone. My name is Marie, and this is Sam, and we're going to kind of tag team the therapeutic prison approach, which I think is a good segue after what Caitlin talked about with rehabilitation. So we visited Grendon Prison, which was established around the 1960s, and it's a therapeutic prison, which basically means each person who is incarcerated there has 3 days a week of required group therapy and 2 days a week of individual therapy with licensed therapists. Each inmate has their own individual cell. We kind of toured around the prison, and there's, a lot more light than, we saw at Pentonville. And the staff relationships with inmates were also relatively more informal. We were only there for about an hour or so we didn't get, a super detailed overview, but that was kind of our impression while we were there. Talking a little bit more about how you can get into Grendon. It's basically a self-selecting group. So if you're incarcerated in the UK, you must volunteer in order to get into Grendon. And then there's a 6-month assessment to basically demonstrate that you are willing to put in the work to do this therapy. Then you must complete 2 years there, and if you still have a remaining part of your sentence, you'll go back to a regular prison. A couple of things to note is that basically some of the inmates are removed if the approach is not really working for them, but you might also deselect voluntarily, and that's how most people will leave Grendon. A couple of the conversations we had while we were there, we learned that basically if you're you can be, I think it was interesting because a couple of the inmates talked about how it was really intensive therapy. So, you have 5 days a week of therapy. If any of you see a therapist generally, you know kind of how exhausting and emotional that work can be. And so 5 days a week for 2 years, a lot of people talked about was kind of an intense experience. However, the purpose of it is to reduce recidivism. And one person told us anecdotally that it is an investment by the government. So basically, someone who is in Grendon will cost the government about $100,000 a year, whereas an inmate in a typical prison will cost the government about $38,000 a year. So there is quite a disparity. But like Caitlin mentioned earlier, recidivism also does cost the government money. So it's kind of balancing those two things together. Okay, so one thing that's kind of also unique about Grendon is they'll host a social day, and that's a visit that they host every 6 months. Now, this is different than, a visit with your lawyer or a visit with family members. It's a day that's open to the public, so any member of the public can attend. We learned from a couple of prison guards that former lawyers and judges might attend to follow up, on cases that they've heard or former clients they've worked with. And basically you speak with anyone. So we talked to a couple administrative officials at the prison, and also we talked to a bunch of different prisoners, and we also talked with the guards, and basically it was like they made tea and had, I think, cookies or cupcakes or something, and we kind of all walked around. One inmate showed us the cell that he was staying in, and the format of it is pretty informal. It kind of is just meant to be, a social hour. You float around from group to group and try to have, pretty honest and candid conversations. The goal of this, I think they emphasized, is really to inform and educate the public about the goal of Grendon to reduce recidivism. And And yeah, just educate the public about their therapeutic and rehabilitative approach. I'll let Sam talk a little bit more about the effects of this.
Thanks, Marie. Well, so let's get to the big question. Does Grendon's approach work? And I realize looking at that last picture that I'm wearing the same shirt and pants as I was. I promise they've been washed. But does Grendon's approach work? Well, the nice thing that we have is actually a lot of research and a lot of criminological questions. There's a dearth of research as to the effects of certain programs. But as mentioned earlier, Grendon's been open since the 60s. And English criminological researchers have been interested in studying Grendon since about that time. So in thinking about this question of the efficiency of the program, there have been documented successes in reducing criminalized behavior, primarily with recidivism. Studies show that inmates who complete 18 months of programming at Grendon reoffend at a 10% lower rate. And the fact that this is a study of people who actually completed the programming is significant because it kind of solves for some selection problems in the fact that inmates opt into being at Grendon in the first place. But arguably the greater achievement of the prison is that it is exceptionally safe compared to the other prisons in the UK prison system. And this is even true for Grendon, which is a space that houses a disproportionately high proportion of violent offenders and offenders with certain diagnoses of psychopathy. However, that raises the question, why aren't all prisons just therapeutic in the UK? Well, a couple reasons. First, as Marie mentioned, there's a cost problem. There's a higher cost per prisoner at Grendon Prison than any other prison in the UK system with comparable security facilities. Additionally, there's a lack of vocational training in Grendon Prison. The therapy programs kind of crowd out other vocational training programs, especially in highly relevant fields for inmates being released back into society. Additionally, there's a lack of educational programming. Studies show that beyond basic remedial literacy requirements, there's a lack of any other higher educational opportunities at Grendon Prison. And not only that, but it's trending downward. And finally, there's staffing challenges. It is the staff and guards who are administering a lot of these therapeutic programs and conversations inside the prisons, which requires a higher level of training. That means if we want to expand these kinds of programs, it also means expanding this type of higher training for guards, which is very difficult to accomplish and will require more resources. So turning to the US, let's see a show of hands. Who thinks we have therapeutic prisons in the US? Raise your hands. Okay, who thinks we don't have any therapeutic prisons in the US? Okay, blue shirt. Why do you think we don't? Very cynical. You're in the right place. But no one, I'm kind of asking everybody a trick question because we don't exactly have any prisons that are solely therapeutic in the US, but we do have therapeutic prison model systems inside federal prisons for drug programs. The Federal Bureau of Prisons runs the Residential Drug Abuse Program, or RDAP, as you can see here. And it's a 9-month program that follows the therapeutic prisons model, including segregated living and a half day of therapy every day. And studies have shown that people who participate in this program are, quote unquote, significantly less likely to recidivate. I couldn't find any exact numbers. I imagine they're actually maybe a little bit embarrassing, but nonetheless, shown some less recidivism. And this is offered in 53 federal prisons. So there's already some sort of precedent and some sort of basic infrastructure for potentially expanding the therapeutic prison model in the US. So should we do it? Well, one thing we also need to consider is that the United States might be predisposed to some of the shortcomings of the Grendon system. So remember what we were talking about the lack of educational opportunities in Grendon? Well, in general, the US system offers fewer educational opportunities for its inmates as a whole in comparison to the UK system. That means the difficulties that the UK therapeutic prisons are already facing over there are likely to be exacerbated if we imported it over here. Similarly, the same can be said about vocational programming, as there's a wide variety in vocational programming available throughout US prisons. So if the United States were to import some sort of therapeutic prison system, it would have to come with addressing other greater underlying issues to avoid these similar drawbacks in the UK therapeutic prison system. But query, should we be investing in prisons or communities? If we're viewing this as a zero-sum game, which you can make an argument that it is or isn't, should we be investing our political and monetary capital into things like the Bureau of Prisons and prisons themselves and programming inside, or directly into communities outside? To complicate this even further, does our experience at Grendon interacting with the folks who are in there suggest that it's a misnomer to consider a prison community not a community? Lots of things to consider and question, and unfortunately, I've decided to not consult my crystal ball to tell us the perfectly right answers this morning, so we'll have to kind of live with a little bit of that ambiguity. Thank you for joining us.